Dr. Guche, good morning.
Good morning, sir.
How are you?
Fine,
Thanks a
thank
lot.
you. Thank you, sir. It's my
We
pleasure
need
being
to,
with you today.
we need to hold on a
No problem, sir. Let's do that.
bit for more people to.
Okay, sir.
Thank
Thank you, sir.
Good morning, everyone. Thank you for joining us this morning. Um, we're going to be having some conversations this morning on the Electoral Act 2026 and the role of journalists for transparent 2026 election. Thank you for joining us. My name is Melody. I work with the International Press Center. And this webinar is being organized by the Daily Trust Foundation in collaboration with the International Press Center. Can I please request that we make use of the chat box to introduce ourselves, perhaps your name and the organization you work with, while we just give a little more time for more people to join us. Thank you very much.
Thank you, Melody, for taking the lead. We are expecting more persons to join. But it's almost 200 persons registered, so we expect more persons to join this conversation.
All right, I can see that we have people introducing themselves already on the chat box. Dr. Sam Oguche, you're welcome, sir. Thank you for joining us this morning. It's a privilege to have you here.
Thank
I
you.
can also see Ibrahim Musa Giginya from Daily Trust. Thank you for joining us. Ihoma Nwachukwu has also introduced herself. Thank you for joining us. We have Raphael Ogbonaya, a correspondent from Ekiti. Thank you for joining us. Abdul Karim Aruna, the chairman of NUJ Borno State, is with us this morning. Thank you for joining us, sir. I can also see Mike Tayeshe Prince, the South South Bureau Chief and Bayelsa State Correspondent of Daily Assets Newspapers, is with us this morning. Thank you for joining us. So please let's make use of the chat box very quickly to introduce ourselves, our names, and the organizations we represent. And also see that on the screen we have the agenda. So perhaps we could just run through it to see what the program will look like today. Okay, I can also see Melanie Ishola, the head of program Sponge Videos. Thank you for joining us. Emmanuel Kada from the inside. Thank you for joining us. Human Umachuku is from Orient 94.5 FM. Thank you for joining us. We have Ali Bala Gerengi from Gombe State, correspondent of GTA, Hausa, Amuka. We have diverse journalists joining us this morning from all over the country. Thank you for joining us. We are glad to have you here this morning. So please let's continue to introduce ourselves using the chat box while we wait for a few more persons to join us, and then we start exactly by 10 a.m. That's 5 minutes from now. Thank you very much.
Really?
When I told you, I mean, taking you buy well. This guy no.
Me, I don't know. We don't really, they work. Me, I don't want to put my heart on.
No, they put your phone.
All right, I can see that we have more people introducing themselves using the chat box. Thank you very much for doing that. Can I request that we mute our microphones if we are not speaking or if we are not asked to speak? And perhaps you could also stop your video for now if we are not taking a group photograph yet, because some of the videos are quite distracting. Thank you, Abba. Daily Trust correspondent in Benue. Thank you for joining us. We have Sani Ibrahim Paki. He's also a Daily Trust, he's the Daily Trust Acting Bureau Chief, Kano Regional Office. Beatrice of Trust TV, Maduguri, Borno State. You are welcome. Good morning. Basiwili, you are welcome from Port Harcourt, Rivers. We have this year, Ifi Erobo from Radio Bayelsa. Thank you for joining us this morning. Ladies and gentlemen, once again, good morning, everyone. My name is Melody. I work with the International Press Center. Thank you for joining this webinar on the Electoral Act 2026. We'll be discussing the role of journalists for a transparent 2027 elections. Let me also mention that this webinar is put together by the Daily Trust Foundation in collaboration with the International Press Center. So I think we can set the ball rolling. Also to mention that I have a co-moderator who will be moderating alongside with me, person of Mr. Somi Falobi, the program project manager of the International Press Center. So perhaps in case you hear another voice later on. So very quickly, I would want us to start this webinar without wasting much time. First, we'll be having welcome remarks. We have two very important persons who will be giving us their welcome remarks this morning. Dr. Theophilus Abba is the program director of Daily Trust Foundation. And then we have Mr. Lanre Arogundade, who is the executive director of the International Press Center, Lagos. So very quickly, I don't know if Dr. Theophilus is with us. If you can please unmute your microphone and give us your brief welcome remarks. You're welcome, sir.
Thank you very much, Melody. Thank you for providing this leadership and invite me. I hope you are hearing me.
Yes, sir, we can hear you loud and clear.
Okay, thank you very much. It's quite wonderful for us to be here this morning and to do what we are doing. The Daily Trust Foundation is the non-profit arm of the Daily Trust newspaper media trust group. We do a lot of humanitarian activities and we do a lot of training for journalists. We did training in various aspects of journalism, especially investigative reporting, data fact-checking, and all those. And we do that for over 6 years. We do that for over 6 years now. But in recent times, we've been doing webinars looking at issues around AI, around human interest reporting, narrative journalism, and all those. So recently, we had a meeting at the editorial board, and Comrade Lanre Arogundade was there. He spoke about the Electoral Act and the 2027 elections. And after listening to him, I said, no, this is something that should be escalated. Because we as journalists, we have responsibilities, we have rules to play. The Electoral Act amendment is not just to enable politicians to do the right thing, but then we must play our own role, our own part in ensuring that they do the right thing. And he mentioned several things. I said, okay, look, let's do this thing in a webinar so that more journalists can understand their rules in this unfolding political environment. And that's why we decided to put together this webinar. And I'm happy he agreed with me, and we are doing this today. Over time, we have noticed that journalists have covered bits that they did not understand. For instance, you have a journalist covering the National Assembly who did not understand how the National Assembly should operate. We have journalists covering the banking sector who did not understand the regulatory instruments, in that sector. We had journalists covering the oil and gas sector who did not understand oil and gas. So they were limited to press statements and chance interviews. Even when they conduct interviews, they don't tend to understand even the issues. And so we, on our own, decided to say, okay, let's organize training opportunities for journalists, for them to understand issues in the sectors that they cover. And so when I listened to Comrade Arogundade when he spoke about the Electoral Act and 2027 election, I said, no, we need to understand the Electoral Act as journalists. We need to understand even the new amendment. If you have not read the whole Electoral Act, perhaps if you are exposed to the issues in the new amendment and your own role, it will help you I said, if you ask some journalists, okay, what's the difference between direct primaries and indirect primaries? They will be looking at you. You ask them, okay, the electoral act gives the option of consensus. What is consensus? How is it arrived at? They will be looking at you, say, look, consensus, I don't know, they will just agree among themselves. But if the consensus has rules, direct primaries have rules. So the electronic transmission also, there are rules. So there are a whole lot of things that journalists need to know before they go into reporting. It's not like meet a politician and then ask him, what do you mean by I mean, we don't have direct primaries. What do you think about the direct primaries? Now the position on that, so it was not well done. But you as a journalist, you should know how the direct primaries ought to have been conducted, so that even in your reporting, without you asking Mr. Politician to tell you what happened, you already know whether what was done was right or wrong. And so these are opportunities for many journalists to understand the Electoral Act and also understand the role that they must play. You don't wait for politicians to come and tell you what. And if the politician is giving you a perspective that is not in line with the law, or is not in line with the legal instrument that is used to conduct it, you say, no, 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 this is not true. This is not what the law says. Today, we don't really have any journalists who can challenge politicians and so-called experts, on issues. Whatever they tell them, they take to the bank. And then the bank ladies at the counter will reject them. So I am happy that we are doing this morning, and even people are facilitators. They are experts. They have done a whole lot of work. Like Mr. Sam Obuche, Yaga, they have done a lot of work. You know what Yaga, how Yaga has influenced elections in Nigeria. I don't know whether the right word is influence, but they've done a lot of voter education. These days I see them on Twitter. I see them doing some things on social media, YouTube, a whole lot of education that they are carrying out, which is a lot of work. And PLAC, the Policy and Legal Advocacy Center. If I want to confess that I read their policy briefs, I read religiously. Every time there's any development in the National Assembly, especially, I look forward to what the PLAC will say. So I'm happy that we have Nkiru Uzodi also here from PLAC to enlighten us. And of course, our guy in journalism, done a lot of journalism and a lot of advocacy. To build the capacity of journalists over the years. Actually, I understand he practiced journalism, but I have always known him at the IPC and all the good works they are doing for journalism in Nigeria. So I'm happy that we are here today. I'm happy that also here to take us through these things. All I know is that after this session today, many journalists will be enlightened. They will know they will know the contents of the Electoral Act and what they ought to do, how to report the coming elections, including even some of the things that are happening now. It will improve their reporting. So on that note, I want to say good morning to you all on behalf of the board of the Daily Trust Foundation. Thank you very much.
Thank you very much, Dr. Theophilus Saba, for those beautiful remarks. Dr. Theophilus Saba is the program director of Daily Trust Foundation. Thank you so much, sir, for putting this together in collaboration with the International Press Center. So very quickly, I would want to call on Mr. Larry Arugundade, the executive director of the International Press Center, for his welcome remarks. You're welcome, sir.
Okay, thank you very much. I hope you can hear me loud and clear.
Yes, sir, we can.
All right. Okay. Well, I think I should start by
Thank
thanking Dr. Philo complimentary remarks about, yeah, it's actually been a long journey to
you.
It seems like Mr. Larry is having a bit of network issues, but sir, can you hear us, Mr. Larry Daddy? Let's just give him a few seconds. I guess he's trying to connect back with us.
Sorry for the break in transmission. Sorry about that. It's network, and so I'll continue. Hope you can hear me again, please.
Yes, sir, we can hear you.
Sorry about that. All right. So I was just trying to say that it's not just the 2027 elections we're looking at with respect to the Electoral Act 2026. We're also looking at the off-cycle election in Ekiti and Osun states because both elections would be conducted under the new Electoral Act. And in any case, the Ekiti election and Osun will be the second and third, respectively, to be conducted under the new INEC leadership of Professor Joash Amupito. So it's important to emphasize this. Um, so essentially, we're just looking at the implication of this act for electoral governance, democratic accountability, and media practice in Nigeria. Just as Dr. Theophilus Abba said, this webinar is a direct product of the interface that the International Press Center had with the editorial board of Daily Trust a couple of weeks ago as part of the work that we do under Component 4, Support to Media, of the European Union Support to Democratic Governance in Nigeria program. A part of it was that we should have engagement with media operational leaders. And one of the issues that came up was the issue of the Electoral Acts, the extent to which we in the media understand it, and the extent to which we can monitor the conduct of politicians, the conduct of INEC, and other electoral stakeholders on the basis of the Act. And I was so happy that shortly after that interface, Dr. Abba called to say that they've decided to have a webinar to build the capacity of Nigerian journalists on understanding the Act. So it's a very much welcome, development, for us. As preparations for all these elections gather momentum, the role of the media in promoting electoral integrity and public confidence becomes very, very important. And as we know, credible elections require an informed electorate, a transparent process, and access to accurate information. To that extent, journalists have a very, very critical responsibility to provide fact-based reporting, foster informed discourse, and counter misinformation and disinformation. This is especially so for those of us who moderate live programs on television or radio and even do reporting in the media. Politicians will come with all kinds of claims. But if we are well grounded in the Electoral Act, we can begin to challenge them. We can also properly interpret interventions by the courts when they are necessary. So there's a whole gamut of reasons why we need to have, this webinar. Added to that is the fact that the Electoral Act 2026 has actually generated considerable policy and stakeholder discourse on the key thematic areas, including electoral technology deployment, result management architecture, campaign finance regulation, political inclusion frameworks, and electoral dispute resolution, among others. To what extent do we really understand all this? So we're just trying to emphasize the fact that there's a necessity for a comprehensive understanding of the statutory provisions and implementation modalities of the Act by journalists, particularly in relation to electoral reportage and the public information management. So I believe that this webinar provides us that structured platform for expert interrogation of the media's normative and operational responsibilities in the accurate, responsible, and public interest driven communication of electoral processes with a view to strengthening the integrity, the transparency, and inclusiveness of the election cycles that are before. On this note, we are privileged to have distinguished speakers and resource persons whose expertise, I'm sure, will enrich our understanding of these issues. We've already had the welcome remarks of Dr. Theophilus Abba, Program Director of Daily Trust Foundation, which has provided some foundational background to this discourse. And once again, we want to appreciate him for his own role too in advancing media development and democratic governance in Nigeria. For the technical sessions, we're lucky to have Dr. Sam Oguche, coordinator of Yaga's Center for Legislative Engagement. And I dare say that perhaps we couldn't have gotten a better person to enlighten us further on the Electoral Act 2026. Then the other person too is Mrs. Nkiru Uzodi, Program Manager, Legislative and Gender Issues at the Policy and Legal Advocacy Center, that is PLAC. As some of you should know or may know, IAGA, PLAC, IPC, CIMESO, and other organizations were all part of the cohort that makes up the EUSGN, and that is the European Union support to democratic governance in Nigeria, the electoral process, election administration, the judiciary,
Hello, Mr. Larry Arogudade. We are having a bit of issues hearing you.
women work together in this area. So we have to deliver on this. For example, plaque.
Hello, sir. Okay, I think we are having some network issues with Mr. Arogudade's from Mr. Arogudade's side. But definitely, like he said, journalists have a very important role in providing.
Okay, Melody, can I just conclude?
Yes, sir. Please
All
do,
right.
sir.
So please, just briefly, our expectation is that all participants in this webinar would digest the issues. We would also report on our discourse today, but subsequently use this knowledge to engage, stakeholders and enlighten our communities. In other words, we want to see a multiplier effect of this particular, webinar. We can even have breakdown or step down sessions in our respective newsrooms to our other colleagues. And I'm glad that some of our participants we have an AUJ chairman at least who was introduced earlier. Maybe we have others. Please let's just spread this message as widely as possible. And if you still want Daily Trust and IPC or IPC and Daily Trust to be part of those engagements, we're willing to deploy our expertise to be sure that as many journalists as possible have a very enriched understanding of the Electoral Act 2026. Thank you once again and welcome. And of course, I'm sorry for the break in transmission due to network challenges. Over to you, Melody.
Thank you very much, sir. Thank you, Mr. Larry Arugundade, for those beautiful remarks. Definitely, journalists have a very important role in providing accurate information. Thank you for putting this together with Daily Trust Foundation. And so that was Mr. Larry Arobundade, the Executive Director of the International Press Center, giving us his welcome remarks. Apologies for the technical issues while that was going on. And so very quickly, we'll be going straight into our first session on the new Electoral Act 2026. We'll be looking at matters arising and the role of the media in providing accurate information. To take us through this is that person than Dr. Sam Uche, the coordinator of the Africa Center for Legislative Engagement. We're honored to have him here to bring us through this first session. Thank you very much for joining us, sir. You have the floor.
Okay, thank you very much, Melody. Let me once again thank everyone for making our time to be here, and to thank IPC and Daily Trust Foundation. This is important, as has been said earlier, because information available to the people largely determines their conception about the electoral process. So it's important that we go through the new framework that we have to get ourselves acquainted with the basic things, especially the innovations, so that when we report, we'll be reporting from a point of accuracy. I will just comment by restating the obvious fact that electoral governance is anchored on the Constitution, which we presently operate, the Constitution of the Federal Republic of Nigeria, 1999, the Electoral Act 2026, which repealed the 2022 Act. We also have various regulations issued and guidelines issued by INEC, as well as judicial authorities. I can say that this framework promotes transparency, accountability, inclusiveness, as well as electoral integrity. On this note, what I'll be doing is to interrogate the Electoral Act 2026, and also we'll do it vis-a-vis the role of the media in providing accurate information. Because of time factor, I will go straight into the key innovations in the Electoral Act 2026. And then we look at it. The first thing, we'll just highlight the basic, the key ones. There are some that we may not be able to touch due to time factor, but the key ones that we are required to get ourselves acquainted with. First of all, we have the continuous voter registration under Section 2, particularly Section 10, subsection 2, which now provides, in addition to what we had in the 2022 Electoral Act, documents that you can present, while appearing for continuous voter registration. That is the Nigeria birth certificate, passport, NIN is there also. So this is an exercise that INEC does, and then any of these three. In fact, when we have the Nigeria birth certificate, it also carries the implication that a declaration of age duly sworn to before a competent court can also suffice for this purpose. Then, replacement of PVC. Under Section 18 now, the Act provides two alternative methods for securing the replacement of a lost, destroyed, defaced, or torn or otherwise damaged PVC. One is physical application, which is required to be made not later than 90 days before the polling day. Again, we have this innovation, which is the downloadable replacement copy, which is now introduced, so you can download from INEC website. Then we have another one, publication of election notice. Under this one, you will see that there's a reduction of time. The timeline has now been reduced from 360 that we had in the 2022 Act to 300 in the 2026 Electoral Act. So this is provided for in Section 28 of the Act. And we have some judicial authorities, regarding timeline, the cases like PDP versus INEC in 2022, also PDP versus Silva. So these cases buttress the fact that there is need to strictly adhere to the timeline. So we have the timeline reduced from 360 now to 300 days in Section 28. Then another important provision is Section 29 of the Act that deals with submission of candidates. So here now we have submission timeline reduced from 180 days to 120 days. So under section 29 sub 1, the timeline for submission of candidates by political parties has now been reduced from 180 days to 120 days. And then we'll have, publication of particulars also increased now from 7 to 21 days. If you look at section 299 sub 3 of the 293, of the Act. Then you have another one, consequences of non-compliance with constitutional requirements. If you look at what happened before now, a political party could conduct primaries where the winner is declared ineligible, then the runner-up steps into his shoes. We've had that severally. But under section 29 sub 6 to 7 now of the current Electoral Act, where a political party is found to have failed to comply with constitutional requirements, that candidate and the sponsoring political party stand disqualified. So it is not a matter of the runner-up stepping into the shoes of the winner, but both the party that fails to comply with constitutional requirements and the candidate are disqualified. And if you even go to sub 7, it tells you that where that determination is made after the election, then the court may order a rerun, and that rerun will be to the exclusion of the disqualified candidate and the political party. So in other words, political parties have been put on their toes to conduct primaries that stand the test of constitutionality in Nigeria. That is to avoid the risk of being disqualified. Then we also have the prerogative of INEC to determine the forms to be used for elections. That is anchored in section 42. INEC is empowered to prescribe ballot paper format, which is not new. But if you look at section 63 as well, there is this provision allowing a presiding officer to still proceed despite defect in ballot papers. So that is an innovation in order not to jeopardize due to defect, but if it is substantially, that may carry a different consequence. Then another issue is regulation of polling agents. Under section 43 of the Electoral Act 2026, only accredited polling agents may access polling stations for the purpose of inspecting election materials. Only accredited polling agents. So it is important that we bear it in mind. This has been talked about severally, and it is important that we take note of it. Then another issue which we already have an idea of is the electronic transmission of results. The previous provision under the repealed Electoral Act placed that at the doorsteps of INEC. And we heard from judicial pronouncement that it was not obligatory, even when INEC had regulation. But here now, under section 60, electronic transmission is supported, although there's a proviso there. But if you look at it, even from section 62, there is a preservation of from EC8A as the primary collation document. So even as we are doing electronic transmission, the primary collection document still remains from EC8A, as was pronounced in the case of Article versus INEC in 2023. Then we have the issue of digitalization of membership register in section 77 of the Act. So it is now mandatory to have a digital membership register in addition to hard copies. So submission is required to be done within 21 days before primaries, and failure may disqualify party from fielding candidates. So you discover that the digital register is expected to contain vital information about each member. And you look at it further, each political party is now expected and required to maintain the register, and the names or details of each member that is supposed to contain names, sex, date of birth, address, state, local government, ward, polling unit, NIN, and even photograph of each member. So this tells us that a digital membership register is supposed to provide a comprehensive information about each member. And I know the legislature had a desired result in mind while putting up this provision so that details of each member can be known. You will even discover that when it comes to sensitive intra-party issues, the digital register of members will be a fundamental document to have recourse to. And this is something we should actually take note of. Then we have another issue, which is non-justiciability of internal affairs of political parties. Over the years, the courts interfered substantially in the internal affairs of political parties, entertaining cases, making decisions. But now there is an express restriction of the courts from entertaining intra-party disputes. This is anchored in Section 83 of the Act. So intra-party disputes are non-justiciable now. It means no court shall entertain them. And if there is a violation, to tell us how important the legislature viewed this provision, a violation attracts a sanction of 10 million naira against both the lawyer and the counsel that have decided to go and institute a matter that is on intra-party dispute, which is non-justiciable. So you discover now that because of these sanctions, litigants will be wary, lawyers too will be very careful, and we can say, even before testing the waters, that we may be going away gradually from the era of the courts entertaining intra-party disputes to an era where political parties are given the liberty to resolve their disputes internally. So we have a lot of cases that talked about the sanctity of intra-party disputes within the realm of the political parties being able to handle their affairs. Cases like Usman versus Labour Party determined in 2025, Unoha versus Okafor, which is an old case in 1983, Waziri versus PDP is there, 2023, Suleiman versus APC, and even Senator Samuel Anyanwu's case, which was as recent as 2025. The judgment was recently delivered, I think delivered on, was it on 21st March 2025 or so. So all these cases go to show that internal affairs of political parties should be handled by the political parties themselves. So it raises the political question doctrine. And the legislature has now decided to put it in the act expressly that those disputes are not justiciable before any court. Now we have, again, stricter political party registration requirements. Now under Section 25, applications are required to be filed 12 months before election. And the Act has also introduced an administrative fee of 50 million naira. So an association willing or wishing to be registered as a political party is now required to pay an administrative fee of 50 million naira. So it tells you that those who want to form a political party should be ready to comply with this statutory requirement. It's not a matter of guidelines or regulations of INEC now, but a matter of statute. So you see Section 75 sub 4 further empowers INEC to verify information supplied by associations and reject applications where those conditions are not met or fulfilled. So you will see that even as the Act makes this statutory requirement or provision, INEC is further empowered to reject applications for failure to comply with the requirements stipulated therein. Then Section 75 sub 5 also criminalizing the supply of false or misleading information by political associations and their officers. So what this means is that associations that are applying for registration as political parties must be transparent in the information they supply to the commission. And if they supply false information, it becomes a criminal offense. And so it is one of the areas that the media can probe to verify the authenticity of information that political associations supply to the commission before or as a precondition for their registration as a political party. And so if you look at INEC regulations and guidelines for political parties 2026, which was taken or was issued pursuant to the Electoral Act 2026. There are regulations 1 to 4, prescribed conditions, in line with Section 75 of the Electoral Act 2026. Now, we also have the expansion of INEC supervisory and monitoring powers in sections 82 and 83. Now, INEC is empowered also now to monitor conventions and congresses, and it has authority regarding conventions and congresses, even conferences and political activities. So INEC has that duty, which has been expanded to monitor. And in further operationalizing this provision, regulations 15 and 16 of INEC regarding political parties, now expand, or let me say establish compliance monitoring framework. So if you look at the regulations, in regulation 15 to 16, there is this monitoring framework that INEC has brought on board, for the purpose of operationalizing sections 82 and 83 of the Act, which now expand INEC's supervisory and monetary powers. Then, internal party democracy has been strengthened under this Act now. So it is no longer news that, conduct of primaries, as we have under the Electoral Act 2026, has witnessed a kind of recalibration. That is the nomination process. There's a recalibration of the nomination process, as it is now restricted to direct primaries and consensus. So under the 2026 Act, indirect primaries have been removed. So, and if we look at what happened recently, political parties were conducting primaries and they were also adopting the consensus. And as the Daily Trust officer mentioned earlier, conduct of primaries, especially with regards to consensus, carry a lot of requirements that all the aspirants must consent, their written consent must be secured. So, and if consensus fails, the next option is to conduct direct primaries. And we saw what happened during the direct primaries. Many aspirants were dissatisfied because it was more of a coronation in many places. I think Daily Trust published something 2 days ago from Samson Itudu, where the issue dwelt a lot on flawed primaries conducted by the various political parties so far. And we cannot expect electoral accountability, transparency, and even flawless elections arising from flawed or manipulated or rigged primaries. So it is a lot to do. We have a lot, to do regarding how candidates emerge. Because looking at our electoral process, whether we are getting it right or wrong at the general elections, is a product of what we do at the level of intra-party, primaries, nomination of candidates. If the foundation is faulty, definitely the building is going to be faulty as well. Then we have again enhanced regulation of political party measures. No doubt, we've always had provisions relating to how political parties can merge. But under Section 81 of the present Electoral Act, political parties wishing to merge are required to give not less than 9 months notice to INEC. Not less than 9 months notice. I think this is expected. This is expected to give INEC opportunity to look at the various issues involved and see whether it is feasible or not, provided those conditions are satisfied. And we also had, in 2015, we had this case of APC versus INEC that spoke to the effect of merger of political parties. Again, we have an issue which, though not new, but very important, the issue of notice of convention and congresses. So under Section 82, as I said, even as this provision is not so new, but it is expected that we also familiarize ourselves with it. I said it is the notice is required to be given, 21 days, at least 21 days. So, and we have the INEC regulation in 22 sub 4, making provision for that. And the necessity of giving this notice, was emphasized in cases like Shinkafi versus Yari, Ode versus APC, Yenson Wike versus Peace Society. So where primaries is as a result of death or withdrawal of candidates, you see that is provided for under Section 33 of the Act. So on that note, you will find Regulation 22 sub 4 of INEC regulations and guidelines of political parties, providing that the political parties shall give the commission not less than 5 days notice of such primaries, stating the type, date, venue, and time of the primaries. So even as we say, look, notice generally under the Act is provided, you will find out that if that notice is as a result of death or withdrawal of a candidate, as is provided under Section 33, then the number of days or the length of notice is 5 days, not less than 5 days notice provided for. So you see INEC making regulations for the purpose of operationalizing the provisions of the Act, provided that those provisions in the regulations and guidelines don't run contrary to the express provisions of the Electoral Act. Then we have this movement towards dispute prevention and electoral stability. So if you look at the Act, we have, as I said earlier, stricter timelines for nomination processes. We have expanded monitoring powers of INEC. We also have clearer procedural requirements for political parties, as I itemized earlier. Then we have enhanced verification mechanisms. Then, as we talked about under Section 75 to 87, we have stronger compliance obligations that political parties are supposed to, do their homework diligently in order to avoid the risk of being disqualified. It's not a matter of inheriting votes or someone stepping into the shoes of any other, but outright disqualification. And if you look at the INEC regulations too, there is this provision relating to alternative dispute resolution that was brought in, and that also will be of help. I will move quickly to Section 138, which has to do with election petition. I know my time is just remaining 3 minutes, but I will run over this. Now, in terms of election petitions, we know for sure that the Electoral Act before now has been providing grounds. So under the current Electoral Act, in Section 138, non-qualification is now a pre-election matter. Remember, one of the grounds for election petition used to be that the candidate was not at the time of the election qualified to contest. But now it has been taken to the realm of pre-election and is no longer a ground. So the ground for questioning an election have been restricted now to corrupt practices and non-compliance. Those are the two grounds. So whatever you are bringing by way of election petition must fall within these two, and it's no longer what it used to be. So what is now the role of the media? I said the role of the media extends beyond reporting events. So journalists are expected to inform, educate, and even monitor as far as our electoral process is concerned. So by way of monitoring, you are expected to provide accurate information about voter registration, party primaries, election schedules, voting procedures, even election results. Then by educating the public, it means the media should help citizens to understand electoral laws. And that is why the popular saying that you cannot give what you don't have, you cannot give what you don't have, matters. So it is important that we that are reporting as media or journalists get ourselves acquainted with the fundamental provisions of this law. So we are supposed to help citizens understand the law, the voting rights, election procedures, electoral reforms that have taken place, and even the role of election stakeholders, like election security matters. But then you have to monitor and scrutinize political parties and candidates, electoral institutions, campaign financing, even election conduct as well. And then I will place before us one important issue: combating misinformation and disinformation. And what I have to say is that the 2027 elections will likely be the most digitally influenced election in Nigeria's history, because the Act has introduced technology and it has moved towards digitalization. And if we look at what happens on social media, we will see that there is this rise of artificial intelligence, manipulated videos, fake election results, and even deepfakes. So if you look at all those things, it shows that we have a lot to do. So we have a coordinated disinformation campaign, and and this creates certain risks. So as journalists, we must therefore verify information before publication, and that is part of our ethics. We have to rely on official sources, avoid amplifying rumors, and also use fast-checking tools, to promptly correct inaccuracies. Again, I will look at ethical considerations, which we already know that we should avoid partisan reporting and the rest. And then, what are the key reporting issues for the 2027 general elections? One, compliance with voter registration timelines. Those are things we should prioritize in tracking. Political party primaries, candidate qualification disputes, campaign finance compliance, vote buying, electoral violence. These are issues that, and then we have others: BVAS deployment, electronic transmission, collation procedures, and others. And then what will be the way forward? I've said that media organizations should establish dedicated election desks. We should also receive regular training on electoral law and electoral reporting or election reporting. Fast checking units should be strengthened. And then collaboration between INEC and media organizations should be also enhanced. And I say that journalists should, familiarize themselves with key provisions of the Act, as we say earlier, and public enlightenment programs should be intensified before the 2027 general elections. My conclusion, therefore, will be that the Act has introduced significant reforms that are aimed at strengthening our electoral integrity, transparency, accountability, and public confidence in the electoral process. And that being the case, the media remains a critical partner in the electoral process, and this is through accurate reporting, voter education, fast-checking, and the promotion of informed public discourse. I will now give our takeaway will be that the credibility of our forthcoming 2027 general elections will not be determined on the election day alone. It is a product. It is something that is being shaped today. It's shaped in our courtrooms, in our newsrooms, political parties, institutions, and digital platforms. That being the case, we must bear in mind that the information we publish today may eventually determine the confidence that Nigerians have in the results that will be announced tomorrow. Thank you very much for your time. And this is where I'll stop.
Thank you so very much, Dr. Sam Oguche, the coordinator of the IGAS African Center for Legislative Engagement. So I see already that they are clapping, coming on. Don't be shy to shade him for a job done. Normally, it's difficult or it's not friendly to look at things like Electoral Act with all their section, this section, that section. It gets boring. But he has done a very fantastic work in even bringing out the relevant sections in such very clear terms, very clear narratives that we can see and know the essence of what has been done in the Electoral Act. So I want to thank Dr. Samuel Viche for this very lucid presentation in such a simple manner that makes all the legal jargons, as the case may be, something that we can easily adapt and understand. I want to thank you so much for doing this great work. So we keep the questions for now. We take the second session and then we treat the questions together. So just keep your questions for now and then just hold on when we finish with the next speaker, and then we take all the questions together on the program. So the second session is going to be on the Electoral Act fact sheets, the media and the public interest issues, the Electoral Act 2026 fact sheets, the media and the public interest issues. And we have no other person than our dear barrister Nkiru Uzodi, the program manager of legislative gender issues of the Policy and Legal Advocacy Center, PLAC. Plaque is also well known. They are frontline organizations in this work of reforms, especially as the Electoral Act. And we are glad, we're happy that she's here with us, even to take this session. So if you will, as she gets ready to put on her mic, just give her a clap to welcome her. Yes, send your emojis to say you're welcome. You're welcome. I'm not seeing any. Fine, wonderful. Over to you, our dear sister Nkiru Uzodi.
Okay. Good morning, Sami. Thank you very much. And good morning, everyone. Thank you very much to IPC and the Daily Trust Foundation for organizing this very time event and for inviting me to speak on this very important topic. I think the first presenter, Dr. Sam, has already done a very exhaustive, should I say, coverage of the key amendments in the 2026 Act. So my presentation is going to focus more on what I'll call watch points or flash points, areas to really pay attention to as we go into the elections. So my presentation is not going to be simply about what the Act says, because Dr. Uche has already talked about that, but how the Act now makes, how the Act is now politically and journalistically important, and how, issues of politics, deadlines, party incentives, and public understanding, it can impact citizens as we go into the elections. I actually have slides, and I don't know if I can share my screen, if I'm allowed to share my screen. Okay, yes, I can share my screen. So I'm going to share my slides. Okay. So just to set the context, the 2026 amendment creates new legal rules. It's a repeal and reenactment of the former Electoral Act. And in the Act, there are new points of confusion and, possible areas of litigation and even manipulation risks in the Act. So it really matters, because new procedures, timelines, and compliance duties affects politicians and aspirants who are planning to go into the elections to contest. And there are also incentives, there are portions of the new acts that parties may easily adapt to, and there may be also gaps that can, leave a room for them to evade. And there are also potential provisions that will increase litigation. And of course, there are still ambiguities in the acts. So I'm going to really just focus on eight flashpoints. Initially, it was 7. I just added an 8th one as I was to Dr. Sam. So 1 is the election calendar. 2 is the membership register. 3 is nomination methods. 4 is qualification disputes. Then 5 is INEC results review. That's in section 65 of the Act. Then, of course, results transmission, which we all know is a very, very, issue among politicians and citizens alike. And then, of course, campaigns and the public issues and campaigns, and then election litigation. So starting from flashpoint 1, the election calendar. So the election timetable, like I said, is no longer required technical documents. Currently, of course, we're aware that there are 2 conflicting decisions recently on the INEC calendar. So for 2027 elections, the elections are coming a bit earlier. In 2023, the elections happened a bit later, February, March. But this time around, I think a lot of Nigerians were surprised when the election timetable came out, and it was, it came quite early in the year in January. And, a lot of people actually criticize the decision and criticize INEC, for moving the election date so close, for bringing it forward rather, instead of, leaving it at the usual time that citizens expect that elections will hold. And I know that there were also conversations whether INEC could actually do that, because like Dr. Sam had talked about all the timelines. And usually in the Electoral Act, the timelines are usually a window. If you look at it, maybe it says don't do something not later than so and so days or not earlier than. So timelines in the act are usually not definitive because, of course, INEC has powers to set to determine the dates of elections. That's their constitutional power, but those dates are not very clear-cut in it. It doesn't say you must do this on a particular day. So it gives a window. The same thing with even the elections in the Constitution. It says not later than, not earlier than so and so number of days and not later than. So the question is why push the elections day to the earliest portion of the calendar? And I think those were the issues that led to the filing of this lawsuits. But now we are now faced with conflicting decisions. I've not read these two decisions, but I know that one of it, the Federal High Court voided key parts of INEC's timetable affecting primaries, nominations, withdrawal, substitution, and final candidates list, because really the calendar was very compressed. And with a new act, what was expected is that there will be sufficient time for parties to actually acquaint themselves with the new provisions, because there are so many requirements now, digital registers and the change to the method and mode of primaries. So there are big issues, and a lot of people felt it was unfair and it was going to benefit certain parties. And those concerns are very valid and very real. And there are people who felt, this electoral act has been in the making for a long time, and political parties are not meant to just spring up during elections and should have, within over the 3 or 4 year period, they should have been, preparing for elections and shouldn't be complaining that there are new rules. But whichever path we are on the, on this argument, the most important thing is that the timeline is not just a timeline, not just a technical document. It's should I say affected? It affected the way parties organized for these primaries. So now we have these two Federal High Court decisions. Of course, there's also the issue of conflicting judgment, which I'll come to later. But I think that's a flashpoint. So I think it's very important, for the media to actually, follow these two cases, as they have been, to report these cases as they've been reporting. And if there's any pending appeal, I think INEC has filed a stay of execution on one of the cases. And it's very important to highlight these conflicting judgments, because they are actually not good for parties, aspirants, and voters. And also, with respect to timeline, I think it's also important to watch compliance with timelines, on submission of candidates, withdrawal, substitution. There's a deadline for all these activities, including publication of the final list of candidates and campaign deadlines. I think there was one thing I observed in the Electoral Act is that the timeline for campaign, there's a bit a problem. Usually, final candidate campaign, but I think this time around, the campaign is starting quite earlier, even before the final list comes out. So that's one of the ambiguities that have been pointed out by observers on this new Electoral Act. So then, point 2 on party membership register. So Section 77, I think, is one of the most consequential reforms for internal party democracy. So party membership register is no longer just a general list. So it is now a structured identity-based database that includes detailed personal information such as name, sex, date of birth, address, state, local government area, ward, polling units, NIN, and photograph. So the key public interest point now is that the register now determines who can participate in primaries. So only members' names who appear in the submitted register may vote or be voted for. The use of alternative registers is prohibited, and failure to submit a compliant register within the within the required timeline may prevent a party from fielding candidates. I think that's also a very important flashpoint. So I think it's very important for the media to verify whether parties have compliant registers, how disputes are handled, and whether sensitive data is protected. I think nobody's really talking about also data sensitivity, gathering people's name, date of birth, sex, polling units, address, and the rest of it. And there's also the issue of whether technical defaults could become ballot exclusion. So there have been questions of, what if somebody's details are there, but what if the sex is omitted? What if the date of birth is omitted? I think these are the questions that are probably going to come up during litigation, and that only the courts can determine. And I think Section 77 is very
focal, is a very focal area, because in 2023, in the 2023 litigation, during the litigation period, a lot of petitioners tried to get their opponents or people who won elections disqualified on the basis that they had defected or they had changed parties shortly before primaries, and that there was no evidence that their names were on the party register, and that because of that, they could not say that they were validly nominated. In fact, a lot of that even came in during the post-election period. And the court said, see, Section 77 says a party should submit they cannot manufacture penalties. So, the legislative intent is for people that if that's the legislative intent, then it should be made very clear. So it was on that basis that the National Assembly actually amended Section 77 to add penalty for last-minute defections. And of course, we have seen what has happened with the primaries, that now candidates or rather aspirants are now locked in their parties. It's not as if they cannot move, they can change parties, but they can't, contest, run, or aspire to get a ticket on that party. So then moving to the next flashpoint, candidate nomination. So candidate nomination now, we are all aware that direct primaries and consensus are the only means of nominating candidates. Indirect primaries was removed from the act, which a lot of people celebrated, but now we are beginning to see, the challenge. So there's this point of view that the three methods, that's direct, indirect, and consensus, should have been left in the acts, and parties should have been allowed to determine their mode of nominating candidates. But now people are kind of locked into direct and consensus. And a lot of case was made during the drafting on why direct primary should be removed. But direct primaries also comes with its challenges, as we have seen. Now, delegate primary stands for elite capture, manipulated delegate list, inducement and instigation. But the question now is, has elite capture disappeared now that we have only direct primaries and consensus? Even the so-called consensus, does it mean, is elite capture really out of the picture? I think that's one of the questions. So even consensus, so the argument for consensus is that it can reduce contestation. But from what we have seen, consensus can hide pressure or exclusion if not properly scrutinized. So I think for the media, it's very important to scrutinize, what has happened within political parties in terms of the primaries and the nominations. So for this particular issue, I noted, do not treat party primary generic as direct primary consensus, who voted, which register was used, were party guidelines followed, and did members see the party rules. And I think this is very important because what the Act did was to remove issues of party primaries, from the regulation of the Electoral Act, move it into political parties. So going into it's party rules now that govern. So the question is, the members, the aspirants, how many of them actually saw the party rules? How many journalists really saw the party rules governing the primaries? There are several parties where those guidelines followed. Those are the things that the court is going to be reviewing as the pre-election litigation cycle begins. Then again, 4.3 is still focused on direct primaries. So, like I mentioned, direct primaries may still participatory, but the 2026 Act has removed the detailed statutory safeguards that existed under the 2022 framework. Under the 2022 Electoral Act, there were like a few guidelines, like, okay, if you are doing direct primaries, it has to be democratic, it has to be this. There were like minimum standards. Those provisions are not in the Act anymore. So there were references to ward level voting, participation of registered members, equal opportunity for aspirants, and ratification process. Under the 2026 direct primaries are largely to be conducted according to party guidelines. This means that journalists must pay closer attention to party constitution and guidelines. So the legal context will not be whether a party followed the act, but whether it followed its own rules. And what it also means that this may produce uneven standards across parties and uncertainty in litigation. So overall, I think it's important for journalists to ask for party guidelines and treat them as public interest documents, compare what party promised in its guidelines versus what happened on primaries day, and then conclusion, opaque accreditation, sudden changes in venue or rules, and denial of equal opportunity to aspirants. And then I think it's also important to highlight that the very scanty or threadbare statutory details means that there will be more disputes over internal party rules, because during the drafting, lawmakers thought with these new methods, pre-election cases are going to reduce. But my opinion is that it's actually going to have the positive effect, and there's going to be more pre-election litigation. Then flashpoint 3B, consensus candidacy, peace bill, I already touched on this. Of course, consensus is a lawful nomination method, but it is not simply a precedent by party leaders. It must meet legal conditions, or the all cleared aspirants must collect in writing. Of course, we need to treat what cleared very seriously. Cleared. So I think that's something that's going to come up in the court. What do you mean by cleared, and who cleared them, and what did the party rule say about clearing aspirants? So the law says that all cleared aspirants must consent in writing. That's for consensus, and the consensus outcome must be properly ratified. If consensus fails, the party must revert to direct primaries. So the public interest issue here is that consensus can be used either as a legitimate agreement or as a tool of early pressure. And it will be important for the reporting to not just focus on consensus, like a consensus candidate emerges without really asking or questioning whether all cleared aspirants consented, and whether any aspirant later objected, or whether the required ratification occurred. So the next flashpoint, or the next issue, shows how this legal change connects to what we have discussed earlier on, which is candidate qualification. I think for me, this is a very, very crucial issue to monitor. Dr. Okuche had mentioned about grounds for election. So in the previous acts, there were 3 grounds for election: non-compliance with the provisions of the act, or corruption, failure to win lawful votes cast, and then that the candidate was not qualified. This particular item, non-qualification, has been removed as a ground. So what it means is all issues relating to qualification has now been, should I say, front-loaded, or has been packed into the pre-election phase. So under the amended framework, journalists need to pay attention earlier to nomination document. Affidavits, false affidavits is a very, very big issue in elections, especially in the courts. Fake qualifications, age, and the rest of it. So it's important to really pay attention to that. I particularly am very critical of this move, because there are some nomination issues that may not be discovered until after the elections. And for pre-election matters, there's a timeline for filing pre-election matters. You have 14 days from the day the cause of action arose. So if the candidate submitted a false affidavit, you have 14 days. After 14 days, you are statutory barred from filing a pre-election matter. That's 14 days from the day the cause of action arose. So with qualification being moved around and now being packed in the pre-election phase, 2 things that have emerged. One, no other person can question non-qualification. So even opposition parties cannot question the qualification of a candidate. That is a very, very big issue. Only aspirants who participated in that primary can question a fellow aspirant's qualification or lack of. In the 2023 cycle, qualification issues were mentioned. And we have to remember that qualification is a constitutional matter. Qualification for election, this age, being a certain age, being a citizen of Nigeria. So saying that those issues can only be raised by aspirants during pre-election suits, for me, personally, raises a question. This is a controversial issue among lawyers, but I think it raises serious constitutional issues. And the law is saying that it cannot be raised after by virtue of it now being removed as a ground, because you cannot file an election petition on grounds that are not stated in the Act, is going to, I think it's going to really be a very contested area, because even in 2023, qualification issues were the most contested. Out of all the grounds, qualification was one of the most contested and one of the most controversial issues. And even though the courts at that time, the Supreme Court had said that a lot of candidates were now bringing party primary issues, even issues having to do with what congresses, how political parties organize primaries, that they were mixing a lot of things and trying to tie it to qualification. And I think the court also advised that there should be like a kind of a separation, which the National Assembly tried to do. But in doing so, I think there's now further constitutional issues being raised, and I don't think this has been done very neatly. So the key public interest concern here is access to remedy. If qualification issues must be litigated earlier, especially by aspirants through pre-election matters, then late media scrutiny may come after the effective legal window has closed. So journalists therefore must have a stronger responsibility to scrutinize candidates' information before elections, not merely after a candidate has won. So, and I think one of the things that journalists expected to do here to build candidate document checks into pre-election reporting, track affidavits, educational claims, age, citizenship, party membership and subscription documents, and also explain the legal windows to the public, because some issues may be too late, not raised at the correct stage or within the correct time frame. So the next issue is how this legal change connects to another pressure point journalists need to monitor. And this is section 65, which is INEC's new power to review election results. So section 65 is a major result management flashpoint. Under the 2022 framework, the provision dealt with the finality of a returning officer's decision on ballot validity and results declaration, while preserving a limited INEC power to review declarations and returns within 7 days. I think it's very important to actually pay attention to this section, because I know that recently a former rec, was on TV saying some clauses were smuggled into the Electoral Act. I think particularly there was a mention of a provision saying that a returning could overrule a presiding officer on ballots, and something about printing ballots. So I think it's a misunderstanding there. So what the Act 2022 says is that when it comes to counting of ballots, like on max ballots paper, if there's a ballot paper without official marks, so ballot paper without official marks means the ballot paper maybe that is like INEC. And if during counting there is a dispute over the validity, and the returning officer can, looks, kind of investigates, and he's convinced or satisfied that it comes from the stack of ballot papers supplied by the commission, then they can count that ballot. So, and I know some people interpreted it to mean, that politicians can print ballots. That provision has been in the Act. The main amendment there, which should be of greater concern, is the one of reviewing results declaration. So in the former Act, INEC could review declaration and return within seven days. But under the 2026 Act, the structure has changed. So the provision is now narrower and focuses on INEC's power to review a declaration or return where the commission is satisfied that the declaration was made under duress or knowingly and willfully, contrary to the collation procedures in section 62.428. Section 62.428 that outlines collation procedures. So the difference between 2022 and 2026 Act is that now you need an INEC official to trigger a declaration. In the former Act, there was no mention of who could trigger a review, but now it must be an INEC official that can trigger. So candidates really cannot trigger a review of election results. And now it's also narrowed to collation. And that's that specificity is not there. So the challenge is that in that provision in 2022, it said that a returning officer's declaration was final. And the interpretation there, what it meant is that once a result is declared, you can only go to court. So that provision that says that only a court can review a declaration, that only a court, like the judicial, that provides for judicial review for INEC reviewing result, it has been deleted. And I think the import is because INEC is now being given, should I say, is given powers to review declarations that does not go with collation. I think maybe the drafters felt that there was a need to say it is not final, because once they announced, they've announced. But what this law is saying, once the result is, INEC can revisit that declaration if it is satisfied within the declaration procedure. So just to reiterate what I said, it's important because the earlier expressed statutory finality of the returning officer's declaration has been removed from the Act, and it may have been intended to make room for INEC's review power, but the provision does not clearly state what happens after review. For me, this is an ambiguity in the law, because if you say, okay, go back and review a return or a declaration that you made, then what happens? So if you go and do a recount or review, are you going to issue a fresh declaration? It would have been good for the Act to be more detailed. So there's a bit of an operational uncertainty there, except INEC addresses this through its guidelines. So it's very important for all these new provisions for INEC to have very detailed guidelines. I think that's really a flashpoint too. Where are guidelines for the election? We have Ekiti elections coming up. Has anybody seen? INEC by now should have the regulations published so everybody knows what to expect, because sometimes the Act is not very detailed on, they don't drill down into the specifics. It makes a very broad provision, and then the Commission is now expected to now make like detailed regulations saying, okay, this is what happens, give a step-by-step guide. So in terms of reporting, I would say, do not report every declaration. Settled. Declarations are not settled, because if they review, then it means there may be a different result. But that doesn't mean that INEC can open it, because judiciary still has constitutional, they still have jurisdiction to hear challenges to election results. But it's also important to ask what evidence supports claims of duress or breach of collation procedure. Then important to also track who requested a review, if there's a review, when it was requested, what procedure INEC followed, and how the review interacts with election petitions. So I think it's very important. It's also important to know the difference between the declaration, between INEC's administrative review, because what INEC is doing is administrative, and then there's also the judicial review or judicial challenge. So it's important for the public to actually understand the difference. So with that, let's look at why the media lens is important under the amended Act. So flashpoint 6, results reporting. This is results transmission, which was, of course, should I say, this was the most important part of the election for citizens and civil society, with the new provisions on IREF. But of course, from the provisions, IREF is a transparency tool. It is not an automatic declaration. It is not outcome determinative. So I think it's important that the public understands that IREF is actually a mirror, and that in the physical results form remains critical, especially where transmission fails. If there's no transmission, accounting. So it's important that the public understands that. So yes, immediate risk, yes, confusing visibility with finality, and uploaded results is evidence for public verification. So I think one of the good things from this provision is that by mandating that results are transmitted, even though there is a proviso, I think it's good because it creates a basis for stronger evidence to be generated for post-election proceedings. Because one of the challenges litigants always have is, they are not able to see what happened on the IRF, they're not able to compare results. So in spite of the fact that there's a proviso that says you shouldn't count, the fact remains that the law says that results should be transmitted. So I think it's going to be very helpful to candidates who need that information for verification of results during the election period. Then moving to flashpoint 7, for me, I think it's just focusing on inclusion and campaigns and fair media access. So I think these are very important because they affect the legitimacy and fairness or perceived fairness of the elections. Public media is required to provide fair and equal access to parties and candidates, and journalists should track whether state resources are being used to advantage incumbents or disadvantage opponents. I think there's also need to also track the campaign period, to watch for hate speech, identity or religious-based campaigning, intimidation, inducement, and sponsored disinformation. All those are electoral offenses. And I think it's also important to monitor voter inclusion, access of persons with disabilities, which is mandated in Act, elderly voters, IDPs, and the rest of it. These refugees, migrant detainees, and these were things. So the reason why I mentioned this is because this is the definition of a definition in the Electoral Act, which is still there, which actually shouldn't be there in terms of vulnerable persons. That is one of the ambiguities in the Act, which was not cleaned up, definition. So in the definition, really, the body of the Act is focused on persons with disabilities, elderly voters, and IDPs. Then moving to flashpoint 8, election litigation. So I've spoken about election litigation, at least I've mentioned it as I spoke on my other slides, but for pre-election litigation, it's important to watch for disputes over party membership registers, conduct of direct primaries, field consensus arrangements, substitutions, withdrawal, and any changes to timing or jurisdiction. And then also it's important to track whether cases are being filed in legally prescribed timelines and whether courts are interpreting the new primary election rules consistently. Then for post-election litigation, we foresee cases challenging result, collation declarations, INEX review powers, IREV, electronic transaction, nomination complaints are being raised to and it's important to also distinguish clearly between matters that belong in pre-election cases and those that can still be declared. Recent National Assembly passed an amendment to Section 29 of the Electoral Act, and so what they wanted to do was to reduce the levels of appeals. There's actually a constitutional amendment pending before the National Assembly. So the whole point was to make pre-election matters just go twice, trial and appeal. And we of the media house have reported on post-election matters, and one of the major recommendations that came out is that election disputes should be concluded before swearing in. And then one of the ways that can happen is to reduce the timelines, or reduce timelines and compress levels of pre-election matters. In post-election matters or post-election petitions, candidates for legislative elections only get 2 chances. They get tribunal and court of appeal, but the governors get to go to Supreme Court. So that's a difference. And we saw how that's affected the Plateau State candidates that had won elections, how they went to the Court of Appeal and lost, but the governor was able to go up to Supreme Court. So during deliberations, the National Assembly, the conversation was keep this to 2 levels, especially for pre-election matters, because the question is, why should you be able to litigate a pre-election matter at 3 levels? You can go to Federal High Court, then you go to Court of Appeal, then you go to Supreme Court. That's for everybody. But when it now comes to the election proper, we only get 2 levels, Tribunal and Court of Appeal. So it really doesn't make sense. Why are we expending state resources, pre-litigating litigation 3 levels? And in 2023, there were cases where the outcomes, the final decisions and outcomes on pre-election matters were coming on the eve of elections. In fact, case where the Supreme Court asked for someone's name to be substituted on the eve of elections. And I remember that particular candidate saying that INEC was evading service. And I remember talking to somebody and like, why would you be bringing a substitution on the eve of elections when we finish printing ballot papers? These are very serious logistics matters. Candidates who contested elections only for them to be removed after they had gone into the elections and election matter. It is, this is something that should not be happening. What we're talking about. The whole idea was to knock down pre-election litigation to 2 levels. It's not been concluded. The Assembly tried to make the amendments to Electoral Act. So last month, there were reports of amendment to Section 29, now making the hearing or the trial level, just keeping the hearing of pre-election matters to just 2 levels. But I don't think the amendment was signed. I know it was passed by the House of Rep and the Senate. The reason why I'm flagging this is because it's very important for the media to actually just keep an eye on this particular amendment. because again, it raises the question of why was such a very critical amendment being made very late in the day, because I think this happened shortly before primaries commenced. If that amendment is not signed, it means we are going to continue with what happened in 2023, which is people can file pre-election matters at Federal High Court, go up to Court of Appeal, go up to Supreme Court, and that there's a likelihood that what happened in 2023 will happen again, which is that some matters will still be coming very close to election period. And this creates serious logistics and operational challenges for INEC, even for political parties and for voters who can go in and vote for someone, and after they will discover that there was like a last-minute substitution by the courts. So I think that is overall key questions to ask: which law is enforced today, which deadlines apply, aspirants filing in the right courts, and judgments changing candidates. For me, I think that's a key public interest issue, because there's a sense among public and citizens that the courts are indirectly choosing leaders for voters, and that shouldn't be the case, and that the court shouldn't just be substituting or changing candidates. So for me, I think that's a central issue that I see resurfacing in 2027, and I think the media should focus on. Then flashpoints, okay, so just to cap up, Dr. Gucci already spoke on this misinformation. I think it's very important to verify facts before publishing or amplifying, especially when it relates to legal issues. So, it's important to clarify the source, the timing. And I think for legal issues, it's important to cite the section that supports it and, what that means for candidates and for the electorate. So in summary, when IPC sent me this information, I think they talked about also flagging the positives. So this for me is just basically a summary of, should I say, the potential opportunities and risks in the new Electoral Act. So potential opportunities: formal statutory recognition of electoral transmission of results. I think that in the proviso, it is an incremental change from 2023, and it's something that candidates, the public, can latch on to ensure that the results management process is fair this time around. There's stronger administrative regulation of political parties, earlier resolution of candidate qualification disputes. So that's the positive from qualification issues being moved as a pre-election matter. That is it. So they are resolved earlier. Then, of course, greater transparency during result collation, because now INEC can review results that did not follow the collation procedure, but there are still risks. One is the compressed timelines that may strain INEC and party preparation of vote registration. Now, we have seen litigation over this matter. Then expanded INEC regulatory powers require consistent and impartial enforcement. Higher campaign spending limits. Money is a big issue. We saw that all the campaign limits were increased across all levels of office. And this will deepen financial barriers to politics, especially for women and young people. Then, of course, there are still enforcement gaps. Electoral offenses are still in the acts. In 2023, people were not being prosecuted. This is probably going to happen again in 2027. There's weak deterrence on prosecuting electoral offenses. And as long as this continues, people will keep getting away with manipulation and electoral fraud. Then, of course, the issue of qualification complaints not being able to be raised for selection, for me, it's an issue that could be very contested. Then election day reporting. I think I'm just going to probably just over this, because this is not really a legal thing, but just suggestions, like a checklist for reporting on legal issues emanating from elections. So in closing, I think this is what citizens expect from the media, to explain and make the legal rules understandable and simple to digest, to verify news items and contextualize, and also, protect citizens, avoid content that inflames, intimidates, or endangers voters, and also to follow up, to track enforcement remedies and institutional accountability. So my final message is that, the media is expected to look at the law accountability framework, not just the technical amendments. Thank you very much.
Wow, what a very insightful session that was. Thank you so much. I already see the emojis, the hand claps, and the thumbs up. Thank you so much, Nkiru, for taking us through that session. It was very insightful, very educating. Thank you most especially for highlighting what the risk and the opportunities in the act are, and also bringing out what responsibilities journalists have, the role that we have to play in all of this. Thank you so much. We really do appreciate your time and for taking us through that very powerful session. Thank you very much, Nkiro.
Okay, thank you, Melody. Thank you, Nkiro, and thank you, also Samoguchi, for laying the foundation and actually building on it for us to understand the nitty-gritty of the new provisions of the Electoral Act 2026. I know there will be questions in terms of understanding of the issue. So now is the time. I'll look at the chat. Perhaps there are questions there. But while I look at that, if you want to make a comment or ask a question, you can also use the raise hand icon so that I can recognize you and have you ask your question. So you just do that, Dali. And so I'll be that for your hand indicating that you have a question to ask. So I already see it. The device is Ahmad Dati. I think that is what is showing. Any other person? I've also seen Abdul Karim. Where is it? Is there again? So you have two hands already.
Abdul Karim Haruna. Sami, maybe you should ask people to use their real names as signing.
Yeah, because it's not showing very well. Okay.
Samsung and all these things. Please, you put your full names. Let them put their full names.
Okay, please do that. So while we wait for that, we have Ahmed Dati and Abdul Karim Haruna in that order. So please unmute and ask your question or your comments, starting with Ahmed. Or Ahmad, rather.
Have a look at problems.
So Ahmad, that's it. I'm waiting for you to unmute yourself and ask your question or your comments.
Hello, can you hear me?
Okay, please go ahead. I see you have a double
Yeah,
device.
my question has to do with internal affairs political parties. Currently, Napi will be a factional chairman, or who claims to be the factional chairman of ADC in court, challenging David Mark as the chairman of the party. I don't know, how do you place this within this provision of the Electoral Act on non-justiciability of internal affairs of political parties? I don't know whether you get my question.
Well, I think so. Although there were some technical
factors
Sorry?
That's the standard.
Hello?
Please share that question again quickly. In just one straight sentence.
Yeah, on internal affairs of political parties. That is non-justiciable. What would the first speaker say regarding the case instituted by Napiu Gombe against David Mark, against his leadership of ADC?
Okay, that is taken. Thank you so much. Abdul Karim Haruna, a question, please.
Yeah, thank you very much.
Every other person should please mute. If your hand is not up, you are not yet recognized.
Okay, should I respond to that?
No, let's take the second question. Abdul Karim Haruna.
Okay, thank you very much. I am Abdul Karim Haruna, Chairman, Nigeria Union of Journalists. Before my question, I want to really commend and thank the Electoral Center and the International Press Center for this wonderful webinar. In fact, it's so resourceful. At the beginning of this webinar, Dr. Abba said something about journalists going into a bit they don't really understand, and they continue to rely on maybe press releases, and they made a lot of mistakes. I think this is an eye-opener, and I want to say that as an NJ chairman from Borno State, we are looking at the possibility of we stepping down this training. And if at any point we need the support of the IPC and the Daily Trust Foundation, we are still going to let you know. But honestly, it is a very educative session. Quickly, my question is, when Mr. Oguche was making his presentation, he said something about registration of political party members, having digital registration and so on. And something flashed through my mind that is it allowed ethically? Maybe any other person can answer this question among our organs that are here. Is it allowed for a journalist who is covering an election to be a card-carrying member of any political party? That is because there's been an issue. We have journalists. Sometimes we don't even know whether they're journalists, whether they're politicians. You see, they're card-carrying members. Some are even participating in party primaries and so on. So I want to know, is it ethical for a journalist to be a card-carrying member? And then secondly, at what point does a candidate and a political party stand disqualified, since pre-election matters like qualification can no longer be people cannot petition such after the election? At what point does a candidate and a political party stand disqualified? Thank you very much.
Okay, thank you so much. Can we just take those first two questions and then we take the second round? I think most of them is for Dr. Gucci, but of course.
Yes. Okay, thank you. Let me start with the first question, citing the example of the ADC leadership person. Now, what I can say here is that internal affairs of a political party, for the purpose of litigation, will be categorized into two. Why that of leadership is fighting for the soul of the political party, it cannot properly come within the confines of Section 83, because a political party must exist before you talk about internal affairs. It must have a leader, and you must talk about which faction is actually the right one. So that will not come under Section 83 for the purpose of non-justiciability of internal party disputes. Then the second question relates to whether journalists should be card-carrying members of political parties. Journalists are Nigerians. They are Nigerians. You are non-partisan. Your duty is to put information with the public. Non-partisanship does not mean that you don't have your political beliefs. Does not mean that you cannot exercise your. It's a constitutional right. Remember, in the build-up to the 2020, to the enactment of the Electoral Act, there was a move. In fact, it was supported by Young Africa at the point, up to the time it didn't scale through, that there was a move to insert a provision in the Act providing for early voting. Journalists are among those who are disenfranchised. You don't participate because you're on field. Journalists, election observers, security personnel, and the rest, but it didn't go through. So nothing stops you, subject to what your experienced colleagues there can say by way of ethics. And then the last question relates to what stage a verdict of disqualification can be passed. A verdict of disqualification can be passed at the pre-election stage by way of institution of an action. By way of institution of an action. You know, when you institute an action as a pre-election matter, the court can, because at that point it's not before any tribunal, it's before a regular court. All pre-election matters are before regular court. So at that stage, it can be determined. And if it is determined, you will discover that it can be determined either before or after elections. As Kiri said earlier, there are some political disputes.
All right, thank you.
Yes, there are some litigations that start from pre-election stage and even go on to appeal up to the Supreme Court.
We lost him.
Hello, can anybody hear me?
Yes, I can hear you from here, but we cannot hear him.
Can you hear me?
Okay, please go ahead.
Okay, at what stage did you miss out?
Well, if you can, maybe
Okay,
the last
okay.
1 minute, so you can repeat what you said.
Okay, I said that the first question relates to whether the Gombe example falls within Section 83 of the Electoral Act. That is, whether it falls within internal party disputes that is not justiciable. So what I'm saying now is that, yes, first, a political party must exist before you start talking of internal affairs. A political party must exist before you talk about its internal affairs. So that one has to do with leadership tussle. Which faction of the party is the real one? So at that stage, you will not even be having a party because of the leadership to talk about its internal affairs. So that will not fall under Section 83. It is outside what is contemplated in Section 83 because a political party must exist before you talk about its internal affairs because you can't build something on nothing. And then going to the second question, the issue is whether journalists can be card-carrying members of political parties. My response would be that, yes, journalists are Nigerians. They have their constitutional rights. The fact that you are reporting, bringing information, informing, educating, and monitoring events does not mean you don't have your political belief. The only thing is that it shouldn't influence your reports professionally. So if you look at, say, the build up to the Electoral Act, there was a move to enact a provision relating to early voting. Journalists, observers, security personnel, among others, are part of, even INEC ad hoc staff have been disenfranchised over the years. And there was this move to cause them to vote ahead of election, although it didn't go through. So there's nothing stopping you from being a member of a political party. And this is subject to what your other senior colleagues here will say by way of ethics of your profession. Then the last one about the stage where disqualification verdict can be given. A pre-election matter can live until after the elections. If the final judgment comes before elections, at that stage, it will be given. If the appeal is concluded before the election, it can be given. But you will discover that there are some pre-election matters that will go all the way to the Supreme Court, and that final judgment will come after the elections. That is why the Electoral Act, recognizing that fact, provides that if that finding of non-compliance is made after the election, the court may disqualify the candidate and the political party order a rerun, but that rerun is to the exclusion of that party and its candidate. So it can be at any point, either before or after the election. Thank you. That is my response.
Thank you.
Thank you so much. Again, you have shared further insights into the issues. I think we have Joy Hodo's hand up. While she's getting ready to speak, Mike Adedoton was asking, what are the security tips for journalists? I think that will be addressed when the executive director gives his closing remarks. What are the security tips for journalists covering the election? So we have Joy Hodo. After that, we have Basi Willie. That's what I saw on my screen. So those two come. Ahmad, that's here, and please put your hands down if you have answered your questions, and then so that we have those who are yet. So Joe Odo and then Basi Willie, in that order. Thank you.
Okay, thank you. Good morning, everyone. I'm really happy to join the webinar, and it's very, very educative and informative. I want to commend the speakers and the stakeholders that organized this webinar. Thank you very much. On my question, if you were advising editors preparing for the 2027, what is the single most important provision of the Electoral Act 2026 they should focus on to strengthen credible election reporting? Thank you very much.
Thank you for that very direct question. Basi, we give over to you.
Good morning, all. I'm happy to be here. Please, I want to find out, because we have seen a situation in the just concluded primaries that an aspirant from a particular political party, went to another political party and obtained a nomination before he actually resigned. I'm trying to refer to the issue in Rivers State, where the governorship candidate of APC, was until yesterday a member of the PDP. Then what is the position of the law on such issues?
Thank you, Willie. That question also came very clearly. Before we answer the question, Umar Dan Kano, please have the way to have your question so that our panelists will just answer the three questions together. Umar, over to you.
Okay, good morning, all. Well, my question have to go to Dr. Sam, where I want to ask, what is the position of the Electoral Act on placeholder in Nigerian politics? Placeholder, those that will hold a position briefly before the main contender will there. Then secondly, most of our journalists in the country usually write their reports on election results from units level, maybe through the electronic transfer or through the digital means. So what is the position of the Electoral Act on that? Because INEC have been calling on journalists to wait to hear from them first. Thank you very much.
Okay, those are the questions. First, speaking by our representative from Yaga, and then if there are complementary comments, the plaque resource person we also had. So, Dr. Ugochi, over to you, cross.
Yes, the issue of placeholder, the placeholder is one of the issues that the Electoral Act now tries to curb by mandating political parties to, within a time frame, submit a list of their members and also candidates. Now, this is subject to also the constitution of political parties. As it is now, nobody will tell you categorically what the issue will be, because we have to test it judicially. Litigations are ongoing, but we cannot conclude on them until we start having judicial pronouncements. So that is what I can say about that. But that is what the Act intends to curb by asking for details of members as well as candidates, and within specified time frames. So at the end of the day, that may not be working, but political parties can do so now. Some can do that, provided they meet the timelines provided by INEC, but it's subject to judicial pronouncement. Thank you.
Are there additions from Nkuru to what's has been said?
Yes, I think hello, can you hear me?
Yes, please go ahead.
Yeah, I think I agree with him on placeholders, that's dummy candidates. I know this was a feature in 2022 nominations, but I personally think that it's an ambiguous thing, because the Act actually allows for withdrawal and substitution of candidates within specific timelines. So what happened in 2022 was that parties exploited these provisions, and they didn't do it because they were addressing genuine withdrawals. They didn't need to buy time for political bargaining. So for me, I think my interpretation is that that was a great area in the law in 2022, and there has been no change to this 26 Act. So it is more of like a moral and ethical thing. I think what the problem is if names are submitted outside the timeline. So I agree with Dr. Obuche that, you know, the key thing is whatever you're doing, your submissions, your changes, substitutions and withdrawals should happen within the timeline allowed. So it would be very difficult. I can't really pinpoint a legal provision prohibiting placeholder candidates. Then in terms of somebody asked about advising editors on the single most important provision to focus on Act is so everything, almost, you know, the whole Act was changed. So there are so many provisions. I will not specifically flag one particular item. That election transmission issue because that's I think they feel they have the most power and influence at polling level when results are being counted and when results are uploaded to IRF portal. So if things work as it should, IRF portal is supposed to be public. So what it means is that any member of the public should be able to, you know, just log on and see and compare. Is what is uploaded, if it's happening real time, is what I'm seeing on the portal the same thing with what was announced in my polling units? I think for citizens, that's their biggest concern, because that is where the manipulation, you know, people say results, elections are won at the polling unit level, and most of the manipulation happens at collation. So for citizens, for me, I think that is the most key thing. So for reporting, I would say, for me, in my own estimation or in my own, looking at how citizens responded during the public hearings, electronic transmission, I think, was a particular issue that the National Assembly committees really received the most submissions on. So I would say section 63, but I also think there are other provisions that are important. So for primaries, section 77, which deals with political parties, section 77.4, which talked about submission of register 21 days to primaries. Then section 77.5, which says only members' names shall be eligible to vote, those whose names are on the register. And then the party not using a register. So, and then of course the penalty for not using membership register. I think for primaries, for party primaries, and for candidates, for me, I think that would be their flashpoints, because people want to know, did the parties meet this deadline? And what exactly, I particularly am very interested, because from the primaries, we are seeing huge figures. We are seeing, oh, this party, this number of million members voted. And I think it's very interesting and instructive. So it means parties are having millions of members on their register, and this is supposed to be digital. So the question is, this register with millions of members, how authentic is it? Are the people who ran or who are being given tickets, were the names really there? So for me, I think for aspirants and candidates, that would be a very important reporting point. Then I think another provision that the media or editors can focus on is section 84, which, yes, so that's the part that talked about nomination by primaries and consensus. Then of course section 88 3 is the provision that says a candidate and its party can be excluded if they don't comply with provisions of the Act in the conduct of its primaries. So most of in fact, the biggest election disputes are usually pre-election and not necessarily after results are declared. So if journalists miss what happens at nomination stage, they may miss the real story. So I think a key editorial point is that, you know, the battle for the ballot now begins inside primaries, because parties have been given a lot of power. And I strongly believe that party rules of nomination is something that the public needs, media needs to understand. Because the Act is no longer exhaustive. There's no standard measurement or ruler for what's primary, for what's happened during primaries, in terms of the rules for nomination, because every party is now being asked, or that we're asked to use their party rules. So, with membership registers, direct primaries, consensus arrangement, candidate list, substitutions, withdrawal, and pre-election court cases. I think it shows that the battle has now started inside the primaries. So yes, I would say election transmission, candidate nomination, then post-election phase, because as the election cycle moves, I think different things become important. Then, of course, during the elections, like I said, electronic transmission, the collation process. And currently, I will also say Dr. Uche talked on it, voter registration. The deadline for voter registration, I learned, was moved. I think as of last year, they said they were stopping CVR in August. I heard it has been moved. Sorry, I stand to be corrected, but I think that has been moved forward. CVR, there are people who have turned 18. And then with these new provisions on you must have use your NIN or passports, I think it's also a key point currently before we go into the elections proper is what are the experiences of first-time voters going to register? And are we still having this thing of, people register and they are not able to collect PVC? Because it is a huge operational and logistics issue that someone registers and they are not able to get their voter's card. In fact, a lot of lawyers have been saying that it's even unconstitutional. Once that the Constitution says once you are 18, you have the right to vote. So for me, that is where disenfranchisement starts. People who want to register should be able to do so. And if they do so, they should be able to collect their PVCs before election day and not, people hearing stories, oh, I went to collect my PVC and there were stories being told. So I think those are issues that citizens find very topical. Then I think I also had a question on the case of the candidates who until yesterday became a member of a party, that changed and won a ticket. I think we're also asking, we that track National Assembly, we're asking ourselves the same question. But for me, I would say legally, because I don't think legally that means automatic disqualification. So one thing about politicians is that they try to look for gaps, ambiguities, or loopholes in the law. So there's something that could be an ethical issue, but whether it's a legal issue is now a matter for the court. So my question is, at what time did this person cease being a member of this party? Okay, we are hearing this person became a member of this party yesterday, but is that really, is that the time really when the person defected? We don't know, because was this defection announced on the floor of the House? I think it's actually very important questions, but I think if it goes to court, the court is going to be looking at the register. So the question is, was this person already a valid member of this party? And did the person's name appear in the submitted membership register before the primary? So I don't think announcements is what the court is going to be looking at. The Electoral did not say you must announce your movements, and then, or rather, your name must be on the register, and then you must come and publicly announce it. These are little things that lawyers take advantage of during litigation, because I did not announce, but you don't know when I changed my registration. So yes, there is a moral and ethical issue there, but the question is, was this person's name in the party register? So legally, if this person validly left one party and joined another party before that relevant register was submitted, and the person was cleared under the party guidelines, and the person emerged through a valid primary, then the person's candidacy may stand. But if the person only joined afterwards, or the person's name was not in the register, then there's a serious legal vulnerability and issue that should be challenged. So I think for journalists, what you should watch out for, find out the date of defection or the date of membership of the new party, is find out if the person's name is on the membership register. And then eligibility, was the person eligible? And another thing is, there are aspirants in that party. If these things are actually issues, you as a journalist, you can report on it, but you don't have any legal remedy. So other aspirants that contested with the person, have they filed a pre-election lawsuit challenging that candidate's nomination? So I think it's also, because you can also get more facts. If there's a pre-election matter against that person from another member of their party, then maybe it can throw more light on facts around the person's shifting of parties. And then finally, is INEC going to accept that person and publish their name? So for me, I think it just go beyond defection and whether that person was a valid member of the party. I don't think there's anything that I missed. I think those are the two questions. I just wanted to add to the question about at what point can a candidate be disqualified since they cannot be raised post-election. I will just say the point of challenge now on things that have to do with qualification, like especially false affidavit. It must happen. It has to happen when the course of action, in law, we say when the course of action arises, which is before the election. So once that primary is conducted, once the person submits a document, or you think the person did not validly emerge, an aspirant must file a case. So, because what has changed is that there are certain issues that could have been raised afterwards, after the election, but most of it has been pushed to the pre-election window. So it means that journalists should watch the courts early, especially federal high courts, the filings, the appeal process. I think for me, that's it's in terms of the questions. But please do not wait for the election precision tribunals to start tracking all these issues. The real battle, I think, is going to start from pre-election litigation. Thank you.
Wow.
There's
Just
one
few
more question.
questions.
There was this question that I was asked about how journalists can protect themselves during the election. I don't know, it may not be in the Electoral Act, but if Dr. Nkiru, Barrister Nkiru and Dr. Ubishe can talk on that. How can journalists protect themselves during the election?
I think Sami, you said the IPC will respond to that in terms of tips. I know IPC, they do a lot of work and tips for journalists during elections. So I think maybe IPC can help, or maybe it will be better place to respond.
Okay, I think Ogala is here soon.
Yes, definitely. I know Mr. Ogunade will touch that in his closing remarks. I was just saying that just few questions has brought further elaborations on the issues. So many issues to chew, so many information that has come out from these interactions, even beyond the presentations. The questions has also brought other perspective that will be very useful for journalists. Looking at the comments, I've seen comments like very insightful, informative, illustrative, excellent presentation, wonderful, things like that. I mean, showing that the participants value the quantum of knowledge that has come out of these engagements. I want to thank our resource persons, Dr. Sam Oguche from Yaga Africa and Nkiru Uzodi from PLAC for availing themselves to be part of this discussion. Of course, the Daily Trust Foundation and RPC also working together in collaboration to put this together has been a very fruitful collaboration. We'll be wrapping up shortly, but there are questions that we need to also answer. There's a pending questions on security tips. Somebody also asked about the need for a certificate that will be with the administration. I don't know whether that is possible for this edition, but possibly other editions may be also looking at the possibility of having certificates for our participants. At this point, I want to hand over back to the Executive Director of the International Press Center, Mr. Alan Rogundade, to give his closing remarks and also to give perspective on some other issues perhaps that are still hanging. Over to you, sir, Mr. Rogundade.
Okay. Thank you very much, Sami. And let me start by appreciating once again very, very resourceful resource persons, Nkiru and Dr. Guche, for really, really doing justice to the topic. I believe that we're all better informed, and I'm glad that both of you provided tips on how journalists can enlighten citizens on the Electoral Act and what they themselves should know and follow up. And my appeal will be that for all the participants here, let this reflect in our work. Let us see stories that raise fundamental questions about all this, because that is how we can help the electoral process and ensure that we have credible elections, which is the main essence of this workshop. Dr. Oguche has partly answered the question of whether journalists can be card-carrying members of political parties. Journalists are citizens, and the Constitution guarantees freedom of association. So those who feel inclined are free to be members of political parties, but what they are not free to do is to be biased in their reporting or to, take sides in their reporting. And that leads me to the fact that our profession is governed by a code of ethics. The code of ethics of journalists in Nigeria is also governed by international codes of ethics, particularly that of the International Federation of Journalists. But in relation to election, it's also governed by the Nigerian Media Code of Election Coverage. Daily Trust is a signatory to that code, and it provides various tips on our responsibilities at elections, including equitable access for political parties and candidates. So, which means that even if you belong to a political party, that does not mean that you must shut the door of your newsroom to other political, parties. So these are weighty responsibilities, and I think Nkiru also alluded to this in the concluding part of our presentation: the need for us to be ethical in our reporting of the electoral processes, because ultimately it guarantees us credibility. Because citizens are not fools; they listen to us on radio, they watch us on television, they read us the newspapers, and they draw their conclusions. So at the end of the day, we need to really rise above board. I do have a popular saying that when it comes to politics, the political party of journalists is journalism, and I like to drop that one here. Now, the third point in concluding relates to our safety, our security. We take this very, very seriously at the International Press Center. I've asked the program team to share the link to what we call IPC Media and Elections. There you are going to find the Media Code of Election coverage, and there you are also going to find the various tips on your security. Security at two levels: security at the level of your physical security, how to maintain reasonable distance where you sense trouble, how to even dress on election day and other forms of reporting. But more importantly, your digital security too. That's also very, very important. We will need another session to deal with all that. But there are basic tips in all these things, really, for especially for those of you who will be going on election. There are many, many sources of information for you. We have Dr. Gucci from IAGA here. Yeah, one of the things that IAGA does is to look at the electoral environment in terms of security threats to the election. We also do that. We normally publish what we call election manipulation risk index. So all these things are very, very important. Kuka Center works with political parties. They also do things like that. So if you are going to cover election in flashpoints, then you have to be prepared in terms of how you protect yourself, in terms of ensuring that you share information with your colleagues so that they can know where you are. But more importantly, also checking on your personal health before you go on the field. That is important. My last point in regards to your safety is that as part of this EUSGM program, we're going to be having high level engagement with the National Human Rights Commission and the Office of the Inspector General of Police. We are envisaging that before 2027 elections, we'll be able to come out with a kind of memorandum of understanding on how journalists can be protected in the course of their work. And that would also include some obligations on the part of the security agencies. But even as it is now, security agencies do make available a number of phone lines in case you are in danger. We were in Ekiti for a town hall, and the commissioner of police provided a number, and they will also provide many others. So please, if you are going to cover an election and area, you must have the phone number of the area commanders, the DPOs, the AIGs for the zone, so that if you run into trouble and you need to get across to the police, that will be very, very important. But should your problem come from the security agencies, including the police, then of course, International Press Center will be having hotlines which we'll share, and then our other colleagues too. Please reach out, civil society organizations, lawyers, anybody that you can just quickly get across to say you are in danger. That will be very, very important. Finally, I would like to appreciate all those who have patiently participated in this program. And I'm glad that we have not lost too many people. At the time, we're about 60 something. We're still close to 60. That shows that you value this very, very important, webinar. And we can only be grateful to Daily Trust Foundation for bringing up the idea after our initial engagement with the editorial board of Daily Trust here in Abuja. I'd like to reiterate that we're still very much, available. We have suggested that you should try and step down the knowledge you have gathered here. But should you also still want us to engage your newsrooms, maybe because they are large and so on, the International Press Center will be available to do that. And I'm sure that we can always call on Kiro and Dr. Guche and other people from the organization to be part of this conversation, because we want us to strengthen our knowledge base so that we can report from an informed point of view. I will be so glad if those of us who run live shows to which politicians are always coming to say all kind of things, make all kind of allegations. It's good for you to have all these tips so that even when they talk, you can challenge them or correct them or enlighten the listeners or the watchers or whatever on the provisions of the act, so that they don't just get away with a whole lot of rubbish as they like to do. And that way we can also ensure that we are sanitizing the electoral information order. Thank you very much once again.
Thank you so much, Dr. Lara Mundade, for also capping up those section with additional information and then have a balancing heart that everything sinks in. We also want to ask Dr. Theophilus to please also come in his final words on this session. Dr. Abba, over to you, sir.
Thank you very much, to this. I want to thank you, Dr. Sam and Professor Kiro Zodi. I think our expectations beyond what we thought to get. Because listening to even the tips, yes, that's what journalists can look out for. I know instead of an editor and reporter, there are so many stories that come from what we have seen to from about 10 to this almost 12 now. I don't have questions, but I don't have about 10 questions. So I can't ask them. What I'm appealing to Bureau and give us contact phone number.
Dr. Abba, your voice is not very clear.
Okay, I'm saying that want Dr. Kiro, Barrister Kiro and Dr. Uche to share their contact numbers with us, so that if any of our participants has any question or they have what do they want to do, part of I wanted to find out if you help me, if there are documents, if there are or what to do in certain sectors. So ask them to share their contact. And also need the presentations. Also do a kind of report from their presentations and share on our website. So if you are not receiving our newsletter, to encourage you, share your name and your email address with us, share our newsletter, so you know what programs we have, in the near future. Now, issues have arisen from here, and definitely we're going to do another session on the election, 2027 elections, as we march towards the election. So I want you to keep close to us. Especially if you have your contact, we'll share our emails with you. Our newsletters with you. You know what we are planning, and then you can participate in the future webinars. So thank you very much for coming. And then we want to ask that you should be in touch with us. Thank you very much.
Okay, thank you so much. That is from Dr. Theophilus Abba. Three things he said that would be helpful. He has requested that Dr. Samoguchi and Nkiru Uzodi share their contacts, whether email or phone number. So that should happen now so that the participant can take that for further relationship and further briefing and interaction as the case may be. So I'm sure that will happen. So look out to the chat box for that information. I'm not too sure. We also had a very detailed attendance list. So we can also be getting back to you on other programs. This program is a collaboration with Daily Trust Foundation. It sure means that there will be other collaboration that will happen even as we're starting this relationship. So we want to also have you join in subsequent collaborative activity. So please do quickly in the next 1 minute, share your contact details so that even when this Zoom session is off, we can retrieve that and also add it to the database of journalists and information sharing. Beyond this activity, the IPC also have some other activities ahead of the 2027 elections. And coming into this network is something that is beneficial. So we also want to reach out to you for invitations for other programs, whether physical, whether hybrid, or a Zoom session like this. So we've seen that you are a very well-organized audience, and we like the ambience that we see staying with us for more than 2 hours and participate. So please quickly share your details in the chat box, especially your name and email, so that we can use that to contact you for the activities you may. We make it short offline. We don't want to for that time. IT persons are already taking some of your pictures. But fortunately, some devices do not have names, so we're not able to know who you are even when we are relating with you going forward. But again, those are the learnings we need to put into practice, that when we are in a Zoom session like this, use our name. We don't know who is just watching and we just want to pick up a name. Thanks to Dr. Sam Oguche, Coordinator, Yaga African Center for Legislative Engagement, and to Nkiru Uzodi, Program Manager, Legislative Agenda Issues of the Policy and Legal Advocacy Center, PLAC. Both of them have done very, very well, very beautiful, even in giving us illustrative and insightful explanation onto the changes that have happened with the Electoral Act 2026. I also want to thank the Executive Director of the IPC and that of Director of the Daily Trust Foundation, Mr. Larry Ragunade and Dr. Theophilus Abba. Thank you for staying true with us, for giving us this working guidance, even as we undertook the programmatic portion of this activity. We appreciate your presence, and we look forward that this collaboration will yield even more fruits and more learnings, even as we go ahead to the 2027 election and other issues that has to do with the media development landscape in Nigeria. I want to thank Melody Akinjian for starting off and keeping the pace, and also our colleagues who have been working behind the scene at the IPC, the IT, and other staffs, and also for the Daily Trust Foundation. I want to thank all of you participants that remain with us even to this time. We appreciate and we trust that this relationship will yield even greater benefits even in the months and the years ahead. At this junction, at 12:28, to be a good time to say to end the session, so we can continue our other activities. Thank you all for being with us. I'm going to like 30 seconds to say hello to say hi to, please feel free to do that now. Bye, side. God bless you all. So wait another 1 minute before we log off. The information from Iaga and from Plaque has been sent on the chat. You can quickly copy that before the Zoom is logged off. We also shared the advisory that was used in 2023 elections. It's still relevant. You can also quickly download that or copy that link before the Zoom link is cut off. So we have like 1 minute to do that. And after that, we may just log off.
Log off now.